Good morning, everyone. I'm Daniel Robin, Deputy Managing Partner of Fenchurch Law, and I'm joined by my colleague Chris Ives, a partner and head of financial institutions at Fenchurch Law. Today, we're going to talk to you about some coverage issues that are dealt with by financial institutions, and Chris is going to specifically cover some coverage issues that may arise from the motor finance redress scheme. Before we do that, as always, a bit of housekeeping. For anyone who's registered for this session, it will be recorded, and by tomorrow morning at the latest, you will get a copy of the presentation and a link to the recording. We're going to deal with any questions at the end. For some reason, there's a chat box and a Q&A box. Can we ask that any questions that are addressed to me and Chris are in the Q&A box? Any technical questions such as sound or any technical issues, my colleague Michael will pick that up in the chat box. So any substantive questions, please put in the Q&A box and we'll address those at the end. And finally, everyone will receive a survey asking for feedback after the talk. We'd be really grateful if everybody could take the time, take a couple of minutes to fill that in, because it's really important to us to get feedback and make sure that we're always improving our seminar and webinar program as well. So thank you. So what I'm going to talk about is some coverage issues that arise in financial institution claims. Financial institution claims often don't involve a single insurance policy, but rather potentially span a number of policies, including directors and officers, professional indemnity, or more commonly civil liability policies, crime, sometimes cyber as well. My talk's going to look at some of the regular coverage issues we come across and some tips on how to either avoid those issues via tweaks in the wording or how to address the coverage arguments if they arise. So firstly, I'm going to look at some issues to do with insuring clauses and whether certain claims or losses fit within the insuring clause. And the first issue I'm going to address is whether a civil liability policy is triggered in the absence of a formal third-party demand. So what you see on your screen is a pretty typical definition of claim in a civil liability policy. Under civil liability policies, a claim is typically defined as a demand for compensation or the issuing of legal or regulatory proceedings. The problem that can arise is often financial institutions will have contractual and regulatory agreements, which mean they'll have to automatically indemnify customers or other institutions in certain circumstances. So, for example, where there's a fraud committed by the customer of the financial institution. So, where that happens, often the institution itself, say the bank, is obligated to indemnify because of the rules of certain card providers, but there isn't so much a demand in itself made. There'll be a chargeback notice or something else that means that automatically they're obliged to give the refund. Where the repayment is automatic, what the insurer may say is there's been no demand for compensation and therefore no claim. And in those circumstances, our advice is that there's still potential avenues for rebuttal. So it doesn't mean that it's fatal, but that there isn't necessarily a written demand in the form of a letter of claim or proceedings being issued, because the obligation to refund could itself be seen as a demand. It's not voluntary, and the insurer is focusing too much on the mechanism by which the claim is made. So effectively, in substance, it's still a demand, even though what usually happens is that the money itself may be withdrawn via a chargeback notice, and then there's usually a right to contest it, which is the same as putting in a defence. And what we would say is the question is, it's not how a claim against a policyholder is framed, but rather the substance. And there's some support for that in case law. There's a case called Westwake and Ching, which comments on the fact that you have to focus on not how a claimant necessarily the mechanism or the way it brings a claim, but rather the substance of it as well. There's also a potential analogy that could be drawn with how insurers regularly treat construction PI, so anyone who deals with construction professional indemnity. What often happens with a subcontractor, for example, where they're alleged to have made an error, is the party the main contractor, for example, the employer, owes them money under the contract, and where they're alleged to made an error, they don't bring a claim against them. What they do is they issue something called a pay less notice. So they issue a notice and they say, we under the contract we would owe you 10 million pounds. You've made this error and you've caused a loss of 5 million pounds. So what we're going to do is we're going to pay you 5 million pounds less. And there's no demand as such for the money. They're saying we're just going to pay you less, and insurers regularly accept that as a claim under similar wording under construction professional indemnity, and we'd say that's analogous with what happens for financial institutions. But what I'd say is maybe a fix, because this comes up quite a lot with financial institutions, is that the definition of claim is tweaked to include an obligation to indemnify. So not just any written assertion or demand, but also includes where there's an obligation to indemnify, and therefore you negate that problem from occurring. If there isn't cover under a civil liability policy, then the financial institution may look for cover under the crime policy. So, for example, where there's been a fraud again resulting in automatic payment or an obligation to indemnify, they may look at whether it satisfies the cover under the crime policy. Insuring clauses under crime policies typically can be for frauds, for example, an electronic crime or wrongful act. So they're triggered by the definition of electronic crime or a wrongful act. And the issue that can come up is they cover the financial institution for a loss arising from that electronic crime or wrongful act. And a definition of loss will often look something like this. And what it requires is a direct financial detriment or a direct financial loss. The problem that we've seen arise in practice is insurers, particularly in scenarios where there's a victim of a fraud, that victim is claimed from a financial institution who has then sought an indemnity from the financial institution that's the policyholder. So there's a chain of people. Insurers say, no, the victim is the one who suffered the direct loss. The bank, for example, itself hasn't suffered a direct loss, it's suffered an indirect loss. It's not a direct loss of the fraud, and therefore it doesn't satisfy the definition of loss under the policy. We think there's scope to push back on that, and we often do for a number of reasons. So the starting point is you have to look at what the rules are of interpretation. So we're presuming this is an English law policy. In England, we take a literal, not a purposive approach to interpretation. So the courts look very much at what the words themselves mean and the plain and ordinary meaning of them, as opposed to that overall sort of commercial purpose of the policy that comes further down the line. And the perspective from which it should be assessed is that of an ordinary policyholder. And when you look at this wording from that perspective, what we would say is if a bank has to reimburse victims of a fraud, it is suffering a direct financial loss because it's still the one that's out of pocket. And when you look at this definition, and again, this isn't uncommon, you get a definition of loss and then you get certain carve-outs. What's quite clear is the word direct isn't focusing on the order on which the loss is suffered. It's on the nature of the loss because, for example, loss should not include salaries, fees, commissions, bonuses, profits. It's talking about consequential losses. So it's talking about the nature of the loss, not the order in which it's suffered. And what you'll often see as well is an indirect loss exclusion that will mirror the wording below. So it will say it won't be loss of profits and that type of thing as well. There's a case called Wood and Capita, which helps because that says that you interpret a provision in the policy by looking at the policy as a whole. So where you have direct financial detriment and then, for example, indirect financial loss in an exclusion, you look at those two things together. And what you'll often find is while insurers will focus on, for example, a fraud and, well, you weren't the direct victim of the fraud, that's not the way this should be interpreted. What you should be looking at is the nature of the loss. And we would say it would cover scenarios where a financial institution has to indemnify a party, even if it's not the ultimate victim of the fraud. So another issue that comes up, and Chris is going to address this more specifically when it comes to the motor finance scheme, is looking at the types of damages. So particularly compensatory versus restitutionary damages. Again, This is a pretty typical insuring clause, and it talks about damages and compensation to a third party, and then it carves out fines and penalties, non-compensatory damages. And so the question that can arise sometimes is what's the nature of the damages? Is it restitutionary or is it compensatory? And what you'll see on your screen is a summary of the different types of losses. So compensation focuses on the claimant's loss and aims to restore the claimant to their position, but for the breach or the wrongdoing that they're claiming for. Restitutionary losses focus on the defendant's gain. So the point of restitutionary losses is the defendant has unfairly gained and there's unjust enrichment. And then non-compensatory damages again, are more those that are aimed not at compensating the claimant, but are punitive, are there to punish the defendant. So a fine is a non-compensatory type of damage. I mean, in England, we don't generally award punitive damages as such, but you can get them in certain types of contracts with liquidated damages. But financial institutions could often find themselves in a situation where arguably what's being claimed could be both compensatory and restitutionary. So, for example, a situation that could create ambiguity is where a financial institution has itself earned commission or fees on sums it shouldn't have had, but the claimant is claiming for those fees or interest. So perhaps on the basis that it itself would have earned interest, or you shouldn't have earned those fees, and now I've lost those fees as well. So the question is, if the money has to be returned to the customer, would it be restitutionary? There was a case in a different context, in a solicitor's professional indemnity context, called Royal Sun Alliance versus Tuans, concerning a solicitor's PI policy. And the Court of Appeal addressed whether a claim for the return of fees paid to a solicitor's firm, allegedly obtained through misrepresentation, could still be covered, could still be considered to be compensatory damages. And the key point is, even in that case, even if they are monies that shouldn't have been earned, it could still be a loss to the claimant because they've paid those fees and they're seeking compensation. So what you really have to look at is the substance of the claimant's claim and what's being claimed. So is the claimant looking to strip a gain from the financial institution, or is it looking to recover a loss? Most times, it may be in practice what's happening is both, but what the claimant is concerned with is trying to recover a loss as opposed to trying to strip a gain. But it depends very much on the nature of it. So again, interested in this example, the claimant's entitled to interest because it's interest they would have earned, or is it because they're saying the financial institution has unfairly gained the interest? So again, it's very nuanced and you have to look at the facts. But insurers will regularly argue those types of losses are restitutionary, but in substance, they may be both, and there's scope to argue as cover. So looking now at some common exclusions that we see in financial institution claims. So unauthorized access exclusion. So this looks at whether or not, specifically in scenarios where the financial institution's customer is the one who's committed a fraud. So it's a customer with legitimate credentials for the financial institution, but for example, they've been engaged by wrongdoers to be a money mule and use their account with the financial institution to facilitate a fraud. So there's a stolen credit card, for example, and they transfer money from that card or a stolen bank account to their legitimate account with the policyholder, and then they transfer the money back out again. And whether or not this would fall within this type of exclusion or not. So on the face of it, it says that the insurers aren't liable for a loss resulting from the use of the systems by a person who has valid access credentials. But then there's two elements to the carve out to this exclusion. So the first one is that it doesn't apply where the access is used for a purpose not authorized by the policyholder, by the financial institution, and with the intention of causing a loss, and this is the more problematic bit, to the financial institution. So what you see insurers argue is that this applies where a fraud is committed using valid login credentials, for example, the insured's online login portal. It's usually unarguable that the first limb applies because a fraud by its nature is not a purpose that's pre-agreed or authorized. So it's nearly always a given that the first limb applies. The trickier bit is the second limb because it says with the intention of causing a loss to the financial institution. Uh, I was going to say 99 times out of 100, but probably even higher than that, where a fraud is committed, the intention isn't, it's not done maliciously. The intention isn't for the financial institution to sustain a loss, or certainly not the primary intention. It's for the fraudster to gain. There is some scope to argue. Well, there's a couple of points. One is that it's so obvious, it's beyond reasonably foreseeable. It's an obvious consequence of the actions that they'll gain, that they'll lose, and therefore you can sort of say by proxy it's almost like intent, but that's trickier. Another point is it does say with the intention, not the primary intention, and so you may argue, well, because of that, yes, the primary intention is a gain, but by doing so, you're causing loss to the insured. But I could see why this language is problematic, because although commercially in practice it would make the cover redundant because it would only cover where there's a malicious act against the policyholder. Again, we're a literal system and therefore it can create some issues. So what I would say is worth thinking about for anyone who has control over their wording is whether or not actually it should just be with the intention of causing loss as opposed to a loss to the insured. But again, you may have to be in a pretty soft market and be on pretty good terms with the underwriter to try and agree that. But it's just something to be alive to, although by no means fatal, and we've had success running those arguments. So the next exclusion, again, which can be problematic, but equally appears in nearly all financial institution policies as a contractual liability exclusion. So these exclusions are intended to apply where liability arises from contractual obligation, and effectively they only arise because there's the contractual obligation. So it typically removes cover for liabilities assumed under contract unless the insured would have been liable in tort or in common law as well. The reason this is problematic for financial institutions is because a lot of the claims that they face, a lot of times they have to indemnify parties, is as a result of their contractual obligations, either with under clearinghouse rules or some regulatory rules, or under their rules with various card providers, or that type of thing as well. And we've seen various instances of insurers seeking to rely on these clauses to preclude cover with a particular focus on the contractual relationship. This is a more favorable version, so you really get two versions of these types of provisions. This one's more favorable because it doesn't apply to all contractual provisions. It has to be either a non-compensatory, as we've covered previously, or it has to be one of three types of contractual agreements. So it has to be an indemnity, a guarantee, or a warranty to a third party. A guarantee is usually a commitment by one party to assume responsibility for the obligations or debts of another in certain circumstances, probably less likely to apply. A warranty is a promise that a certain result will be achieved. So again, I think a warranty is probably less problematic for a financial institution. Indemnity could be the problem because usually what they're agreeing to do is provide an indemnity to another party in certain circumstances. And so you could certainly see with the types of claims they face that it could be considered an indemnity. If it is, then there's a couple of different arguments that apply. So either if it's regulatory rules, so clearinghouse rules or that type of thing, there's an argument to say, well, that's a regulatory rule, that's not a contractual obligation. And it's like, for solicitors, it's like the solicitor's account rules. You wouldn't consider they obligate law firms to make good certain breaches, but you wouldn't consider that to be a contractual obligation. Or you're left looking at the carve out and you have to look at the counterfactual and say, yes, we did agree under the MasterCard scheme rules to indemnify this other financial institution, but we would have been liable anyway in common law or under statute. Often it's complex because these frauds that take place are widespread and are international, and so you have to get local law in certain jurisdictions, and then you have to look at which is the correct jurisdiction with the law that with a fraud that goes through multiple different countries and jurisdictions and everything else. But by no means is it's fatal, but it's better if you can argue that it doesn't come within this at all. The other version that you see that is much wider is just it doesn't have the two Roman numeral in it, so it effectively just applies to any written contractual obligation. In which case, it's then harder because you don't have the argument that it doesn't fall within one of the categories as well. But it's just something to be alive to. I'd say, in an ideal world, you just wouldn't have these exclusions, but I've not seen a financial institution policy that doesn't have some sort of contractual liability exclusion. So perhaps the better thing is, to the extent that you can, is almost trying to have an upfront conversation with the underwriters about framing the wording as such, where the purpose of the cover is really most claims you're going to face are going to be for contractual liability, and you're not looking just to cover where there's concurrent liability in tort or in statute. Then I've spoken mainly about civil liability policies and about crime policies, but this type of exclusion is more common in a director and officer's policy, but again, can be problematic for financial institutions. Or rather, sorry, actually, this one is more helpful, but potentially problematic in the long run for reasons that I've seen. So, a lot of directors and officers cases involve allegations of fraud. That's not uncommon, or a deliberate act. This provision is helpful and should be standard in any well-negotiated management liability policy, because what it does is it says that where there's an allegation of a deliberate act or fraud, the exclusion only bites where that allegation has been made good by judgment or by arbitration or by a formal written admission. And usually it's accompanied by a provision that says that the insurer has to continue to advance defense costs until that point as well. So it's something that comes up a lot. It's really helpful for that reason. And also it usually only applies to the specific insured where the allegation is made, so the other insureds are protected with multiple sort of directors and officers. But a word of warning is, and I'm not hoping there's not too many insurer side lawyers on this, although I'm sure they already know about this case, is there was an Australian case called Oney and Catlin, and it dealt with allegations. It was a D&O case. There was a couple of directors of this company, and they were accused of misappropriation. They had a provision like this in the policy and a provision for advancement of defence costs, and so they said to the insurer, "Well, we deny this fraud, and you've got to keep paying until it's proven otherwise." And what the insurer said was, "Yes, that's right, but you also have a duty of fair presentation under the Australian version of the Insurance Act, and we think that you should have told us about this fraudulent activity. The standard of proof for a breach of duty of fair presentation is just a balance of probabilities. If we think it's more likely than not you committed the fraud, and you should have told us about it, and we wouldn't have written the policy. We don't need to wait for a judgment or for an arbitration. We're not subject to this provision. That's a separate point, and therefore we can avoid the policy." And the policyholder said, "Well, that's not fair because you've got this provision in the policy that says it has to be by a judgment." And the court agreed with the insurer and said, "No, they're two separate things. Like, the test for breach of duty of fair presentation is different, and therefore you can still avoid the policy." And so it's just something to be alive to. Insurers haven't run that argument here. I mean, it's a bit circular because it's still ultimately you'd be denying the fraud and have to prove it, but it's just something to be alive to. So another issue that is incredibly common, actually, among all types of liability policies, but again, something that we see with financial institution is late notification. So the failure to notify your insurer of something within the time frame when you're expected to do so, and the issues that can arise from that. So under civil liability policies, there's the ability to notify a claim, but there's also the ability to notify a circumstance. So a circumstance is something before it officially becomes a claim under the policy. And then Under the crime policy, it's the ability to notify losses, which is a bit different. With circumstances, the ability to notify circumstances, there's two limbs to it, so two ingredients. So there's a subjective test, which is has to be something which the insured is aware of. Sometimes that can be objective in the sense of it's something which they should reasonably have been aware of. Sometimes it's something which a responsible person at the insured is aware of, and the responsible person will usually be someone of sufficient seniority as well. That awareness can be from internal, external triggers. So there's a number of different cases there, for example. So it could be the insured's own concern of something without hearing anything from a third party. So, we think we've potentially going to face a claim in the future, even though no one's externally said anything. It can be from external reviews, complaints, or anything. So it just has to they just have to have that awareness, no matter how it's come to them. The second limb is sometimes the trickier one. So the second limb is objective, and it's to do with the probability. So the objective probability that a claim will be made. And then I'll talk in a minute about there's different permutations, different thresholds for how probable that has to be. The key thing here is it is objective. So it doesn't matter what the insured thought about the likelihood of a claim being made. It's what a reasonable person would think is the likelihood. The second thing is it's about the likelihood of a claim being made, not a good claim. So even if it's a rubbish claim, but it's likely it will be made, or it's reasonable it will be made, it can satisfy the threshold. So it's not that the claim will succeed, it's that it will be made at all. And there's generally there's different versions of it, but there's three thresholds. So may give rise to a claim, is likely to give rise to a claim, and might reasonably be expected. And helpfully, at least, there's case law on what they mean. So where something may give rise to a claim, that's the lowest threshold. And that what the courts have said is that requires just a more than fanciful chance or a realistic probability. So it's always tricky with percentages, but like 5% would be enough for may wording. If you've got may wording, most things that aren't completely trivial are going to satisfy it. The other end of the spectrum is likely wording, and that needs at least a 50% chance to result in a claim. And then might reasonably be expected isn't actually settled, but it's somewhere in between. So a little bit more than just a realistic chance, but nowhere near as high as a 50% chance. So what policyholders need to be aware of is what threshold they have. So the first thing they need to be aware of is what can they notify and what should they be notifying. The next thing is when should they notify? So there's different permutations again about what the notice requirement is. So it can be a fixed notification period. So it can be notify any circumstance within 28 days, for example. Obviously, that's much clearer, although there can sometimes be ambiguity about when it's arisen. There can be something that's a bit more nebulous, so immediate or as soon as reasonably practicable. The difference between immediate and soon as reasonably practicable is the latter takes into account all of the circumstances. Immediate could be by stroke of bad luck. The insured didn't receive a letter or wasn't aware of the obligations under the policy or something. The letter was a one-man band while I was on holiday and I didn't see it for 7 days or something. But you could still fall foul of immediate there. As soon as reasonably practicable takes into account all of the circumstances. So that the case there, the Belest case, for example, was the estate didn't actually know, they knew all of the facts of the underlying matter, so they had something that was notifiable, but they didn't know the policy existed for a year, and that was still considered as soon as reasonably practicable because it was reasonable because they didn't know about the policy, for example. So there's slight tweaks there as well. So you need to be aware of what you need to notify when, and then finally you need to be aware of, just briefly, what the consequences are of not notifying. So when the nature of the condition. So if it's a condition precedent, so it says it's a condition precedent to liability, you must notify within 28 days, for example. If you don't comply, there's no cover. It's strict. sometimes it won't be labelled as such. It may say this policy will only respond to claims or circumstances notified as soon as reasonably practicable. If it's clear what the obligation is and what the effect of the breach is, it will still be a condition precedent, and therefore the obligation is strict. If it's a mere condition, so it's a condition of the policy, you must notify within 28 days, then that's better. The insurer still has to indemnify the claim, but would have a separate claim for prejudice, so it can have a claim for damages as a result of the prejudice it suffered by reason of a late notification, which in principle is quite difficult to prove. I can see Chris getting tetchy because I'm going into his time, so I'll breeze through. I'll breeze through the next couple of points. So, very briefly, the next topic I was going to cover is defence costs. So, civil liability policies tend to include cover for defence costs. However, usually insurers' consent is required. More often than not, that the need is for that to be prior consent, and it might, maybe prior written consent as well. The same could apply for mitigation costs as well. So if that is the case and prior consent has not been sought, then you need to look at how that condition is incorporated into the policy. So again, if the prior consent is just a general condition, so it's a condition of the policy that prior consent is sought before incurring defence costs, we're back into our that's more favourable and looking at prejudice. If it's a condition precedent, it's a condition precedent for cover for defence costs are only available where insurers' prior consent is given. Then again, you don't get the prior consent, no cover. What usually happens is it's actually definitional. So what that means is that the definition of defence costs says defence costs incurred with the insurer's prior consent. And the effect of that is that if you don't have prior consent, you're not within the definition of defence costs, and therefore it's the same as a condition precedent because no prior consent, it doesn't satisfy what a defence costs are under the policy, and therefore there's no cover. So again, something to be alive to and can be problematic as well. I won't cover, I'll just super briefly cover that that if the policy doesn't, there's some case law that's favourable. So if the policy doesn't say is silent on whether consent has to be reasonable or can't be unreasonably withheld, there's a couple of cases there which suggest the insurer doesn't have an unfettered discretion and they have to act reasonably. And what they say is slightly different about that, but there's still some implied term of reasonableness as well. I won't cover reasonable costs. It's worth covering this because it's a super helpful piece of case law for policyholders. And so what's not uncommon, again, for financial institutions is you may have mixed claims. And what I mean by mixed claims is you have a claim where some elements are covered and some aren't. So for example, some elements of the claim could be restitutionary damages and some could be compensatory. And so the question is, well, what happens to how are the defence costs allocated between those claims? Because in practice, what happens with defence costs where you have mixed claims is most costs are what we call dual purpose or common costs. So if you're in proceedings, most of the costs relate to all of the claims, attending a case management conference, attending a mediation, trial, preparing for trial, all of that as well. There may be an allocation provision in the policy which deals with how to deal with those, and it usually says it's based on the respective legal positions and other things. But if there isn't, then what you should be aware of as policyholders is the case law is really favourable to policyholders. So there's a case called New Zealand Products versus, it's actually New Zealand Forest Insurance Company, and there's another case called Thornton Springer. And what they say is the default position is that all costs that are for a dual purpose, as well as all the costs relating to the covered claim, should be picked up by the insurer, and the insurer the only costs that aren't covered are the ones the insurer can prove solely relate to the uninsured claims. So that's something to be alive to when you're dealing with mixed claims. You can breathe a sigh of relief in a minute, Chris. My last topic that I'll cover briefly. So dealing briefly with aggregation, because Chris is going to come on to this more specifically when it comes to the motor finance scheme. So for anyone who's not aware, aggregation clauses determine whether multiple claims or losses are treated as one for the purpose of applying limits and deductibles. So again, this could be particularly relevant in a fraud scenario involving multiple transactions or multiple frauds that have the same MO, where they're all sort of high frequency, low value frauds, for example. And in that case, a policyholder would want them to aggregate because they wouldn't want to pay a deductible for each fraud. If you've got thousands of frauds that are each £1,000, £2,000, you don't want to be in a position where each of those is within the excess. It is horses for courses because you may have multiple high value frauds that you don't want to aggregate because you don't want the limit of indemnities to be eroded. And so you're happy to pay 4 or 5 excesses if you get cover for the full amount of each claim. This is pretty typical wording that you see, and so this requires a series, so it aggregates losses from a series of interrelated acts, omissions, or events. This is potentially problematic with high frequency, low value frauds. Oh, sorry, I clicked off a Zoom there. So there's a couple of cases in a solicitor's PI context that deal with what's meant by interrelated and a degree of interconnection that's required. So there was a case called A&G and Woodman that dealt with transactions, so interrelated transactions, not acts. And what that case, so slightly different, but what that case said is that you need a real degree of interconnection, but not dependency. But similar acts alone are insufficient, so there must be a link between the transactions. So again, you'd have to really scrutinize the nature of the fraud, and the question would be, how do the frauds fit together? Insurers are likely to argue that each one constitutes a separate loss. Another case that I think is more problematic potentially, and that case looked at the meaning of related acts or omissions in a solicitor's PI context, and that was called Baines and another versus Dixon, Cole and Gill. And what that case said is that even a long-running single dishonest scheme didn't aggregate because there wasn't enough interconnection. And what that case said is the question isn't, aren't the acts related, but does the claim or the losses arise from the same series of acts? And what that would mean is where you had fraudsters who committed the same fraud multiple times, thousands of times, for example, with the same MO, they would have to prove that each loss arose from all of those separate frauds, which wouldn't be the case, and there'd be an argument potentially that they didn't aggregate. And again, it's something worth thinking about if you think those are the types of claims you're going to face, whether this type of aggregation wording is potentially problematic. Again, it's not fatal, and I think there are arguments to the contrary. But I'm happy to pick that up with anyone offline because I've infringed on Chris's time too much. So I'll hand over to you.
Okay, thank you, Dan. So I'm going to talk about motor finance and the coverage issues arising. So this is a significant issue affecting the FI sector currently, if not the most significant issue. And we're talking about the coverage issues that arise from the position of the lender, even though the claims involve lenders and dealers. And many of you will be very familiar with the coverage issues, some perhaps less so, but I hope even for those who are not so familiar, you also find this interesting because it puts some of the issues that Dan's been talking about into context. I should add that none of this is legal advice, so you always need to take legal advice in relation to your own specific circumstances. So we are talking about situations where customers are signed up to loan agreements by car dealers, so in the dealership normally, with the finance being provided by the lenders, and the finance is being used to pay for the vehicle. And matters really, this has been an issue which has been widely known about within the industry for several years, but matters really came to a head towards the end of 2025 with the Supreme Court's decision in a series of cases, Hopcraft and Johnson. And that decision clarified the law on secret commission. in relation to motor finance. And the court held that car dealers arranging finance don't owe fiduciary duties to customers, which removed the foundation for claims based on breach of fiduciary duty. However, the court significantly tightened the standard for commission disclosure, and it held that a statement that, for example, commission may be paid is inadequate. So basically, lenders and brokers, so that's lenders and dealers, must disclose both the fact and the amount of the commission. That's prior to the finance agreement being signed. So further, the court found that undisclosed or partially undisclosed commissions can render the lender-borrower relationship unfair under Section 140 of the Consumer Credit Act. And further, the court found in Johnson that there was an unfair relationship where 55% of the loan was commission and that had been undisclosed. And that created a misleading impression from the point of view of the consumer, which again rendered the relationship unfair. So we have, for the first time, there was a Court of Appeal decision, but the Supreme Court confirming that consumers have legal remedies against dealers and brokers, dealers and lenders. And the FCA had been watching situation for a while, and in response to the judgment, they announced an industry-wide redress scheme under Section 404 of FISMA. And the scheme is to cover motor finance agreements entered into between April 2007 to November 2024. And basically, lenders must identify affected customers and calculate the redress and pay compensation directly. I use the word compensation in inverted commas for now. And the FCA's objective is for the process to have completed by the end of 2027. The numbers fluctuate somewhat, but the FCA has estimated that the amount which will be payable to consumers will vary from between £7.5 billion to £10 billion, which equates to approximately £700 per loan. And I guess for today's purposes, what I'm discussing is the extent to which lenders might be able to pass some of those sums onto their insurers. And I'm really looking at it from the point of view of civil liability policies rather than D&O or any other, but there's the possibility for other policies to potentially respond as well. So from a civil liability point of view, the starting point will be whether the redress scheme amounts to a claim for the purposes of the insuring clause, because there will, for claims that are being dealt with under the redress scheme, there will be no third-party demand for payment. So the insurers might be able to say, on the basis of some wordings, that there is therefore no claim. Now, most FI, sort of PI liability policies are bespoke, and are generally claims made, and generally, in our experience, will be broadly defined. So they're not limited to third-party demands, but will also include regulatory proceedings that may result in compensation or damages. And if that's the sort of wording that you have, the Section 404 redress scheme has three features which will potentially bring it within the definition of claim. First of all, the scheme is mandatory, so it must be complied with by lenders. Secondly, it's enforceable by regulators and the courts. And thirdly, consumers themselves may have direct rights if firms don't comply. So a consumer could bring a civil claim against a lender if it failed to comply with the scheme rules. And I think that combination of features will make it very difficult for insurers to argue that the redress scheme is not a claim, as basically we have regulatory proceedings that might result in an order to pay compensation. So on that first point, we would expect most lenders to be able to get off first base and fall within the insuring clause. So far, so good. The next big battleground may well be notification. And as I say, these are claims-made policies, so insurers will be looking very closely at what the insured knew or ought to have known, and whether circumstances should have been known. Should have been notified earlier. And that is in order to answer the kind of key question: when did a lender first know or ought to have known of circumstances which may give rise to a claim, or which are likely to give rise to a claim, whatever wording you have in the policy. Now, the obvious trigger points would be the Court of Appeal decision in relation to those civil cases in 2024, the Supreme Court decision in 2025, possibly even the redress scheme proposals which came in late 2025, or maybe the final rules which were published in March of this year. But we have seen cases where insurers have pushed back and say the real starting point is earlier, perhaps as early as 2019, and that notifications made after that date are too late. And the reason 2019 is an important date, potentially, is because, just going back in time, the FCA announced a review of motor finance in April 2017, but published findings in March 2019. And that report in 2019 is what insurers have sometimes fastened onto. And that report found that commission models might be leading to consumer harm on a potentially significant scale, that customers were paying potentially significantly more for motor finance because of the commission, and lenders were criticised. And it also said, this report, that change is needed across the market. So insurers might say that by 2019, you knew there was systemic harm, you knew it arose from commission paid by lenders, and you knew that your conduct was under scrutiny, and therefore you should have notified as circumstances then. Now, it depending on your wording, of course, in my view, that argument is likely to not succeed for a couple of reasons. So firstly, the 2019 report was looking at a market level risk, not claims risk. So the report is identifying structural issues, not individual mis-selling cases, and not claims. There was no redress framework identified in the report, and almost most importantly, perhaps, there was no crystallized cause of action, because we didn't have the Court of Appeal decision, we didn't have the Supreme Court clarification, so there was no right for consumers to pursue compensation. And really, I would say that the claims landscape, if you like, only emerged from 2024 onwards. And finally, on notification, Dan touched on this, but all we've got really is regulatory criticism, and you need something more, arguably, than the mere possibility of claims. You need a real risk of claims arising from identified facts. So in 2019, the FCA is saying there might be harm, we will regulate the market, but that's not the same as saying there's a tsunami of claims coming down the track. So I think the more likely position is that it's only from 2024 onwards into 25, 26 that the obligation to notify will have arisen. It's not on the slide, but related to notification, sometimes we see insurers argue a failure to disclose information prior to a particular renewal, breach of duty of fair presentation, namely that commission arrangements or the fact of undisclosed commission or partially disclosed commission should have been disclosed prior to a particular renewal. Although, if insurers are saying in relation to late notification, you should have notified in 2019, that could be quite a useful counter to non-disclosure arguments, because by implication, they're saying this was a well-known market-wide risk. You should have notified. It's in the public domain, but that argument actually weakens the insurer's position in relation to non-disclosure, because underwriters arguably were on notice of issues from 2019 onwards. So there's a potential kind of counterpunch in relation to, as I say, breach of fair presentation. Next, again, Dan touched on this. So insurers will often accept that compensatory damages are loss for the purposes of policies, but dispute sums characterised as return of fees or return of commission. So you might get insurers trying to argue in a motor finance context that this is just the return of commission, it's restitutionary and therefore excluded. Now, in most cases, that won't fit the fact pattern of a typical motor finance arrangement where the lender has paid the commission to the dealer. The lender didn't receive the commission itself, and the lender is being required to compensate the consumer. And the FCA scheme is the measure of redress is based upon putting the consumer in the position it should have been, so it's compensatory in nature. And therefore, we're not looking at disgorgement of the lender's profits, or there's no unjust enrichment of the lender. So the payment's not restitutionary. So the commission is really the benchmark that the FCA uses to calculate how much is payable, rather than it being, as I say, restitutionary. So as with all these points, you'll need to consider as against the applicable policy wording. It's not impossible to see how the insurer might have an argument in relation to some wordings, but in most cases, we're not really talking about restitution in the sense that Dan was referring to earlier. So this is my final slide, and aggregation is perhaps going to be one of has the potential to be one of the most difficult issues, because it drives whether millions of customer redress payments are treated as one claim, and therefore whether there's a single limit of indemnity or only a single deductible. Now, I said earlier that claim for the purposes of triggering the insuring clause may be the redress scheme itself, rather than the third-party demands by individual consumers. So in some cases, there may only be a single claim pursuant to many policy wordings, in which case you don't really get into issues of aggregation and arguments on aggregation, single claim, single limit, single deductible. However, that won't always be the case. Dan mentioned a tweak you could make to the policy wordings around an obligation to pay, I think, which might well mean that you have multiple claims when payments are being made to consumers pursuant to the redress scheme. And in those circumstances, you are, potentially into aggregation territory, in which case you need to look at the aggregation wording in your policy, and the outcome could vary quite dramatically depending on the wording in your policy. So, just before we look at the wording, perhaps just to make it the obvious point that policyholders or insurers sometimes argue that claims should or should not aggregate. So sometimes you get policyholders saying that claims should aggregate, so they only have to pay one excess. And sometimes they'll be arguing that they don't aggregate, so they get the benefit of multiple limits of indemnity, where their exposure is expected to be more than a limit. But in general, where you have originating source type wording, that's more likely to mean claims aggregate. So, for example, if you've got a lender who has a central policy decision to pay commission to dealers and to not disclose it, that may well mean that multiple claims arise out of that originating source. Whereas the related transactions or interrelated acts or omissions uh, require there to be, as Dan said, a real connection between the different cases. So where you've got different dealers, perhaps in different locations, signing up to separate agreements with separate customers over a period of time, that may well not satisfy the related transactions type wording. So it will be highly fact specific in each case, but yeah, there's fertile grounds for argument, I think, in relation to aggregation. So I that's all I was going to say. We've got time for a couple of questions. I think just by way of summary, while Dan's getting them up, there is definitely the possibility of making recoveries from policies. And on the basis of many of the wordings we've seen, that's something we would expect lenders to be able to do, although there's lots of points where an arguments for insurers to make. So what do we have by way of
So
questions?
we'll answer a couple and then we can deal with the rest offline, I think, because of the time. So, is there any case law where conditions imparted through definitions have been interpreted as conditions precedent? Well, the point there is they wouldn't need to be, because if you're an insurer and you can say, let's take our defense costs example, that there was defense cost means defense costs incurred without consent and no consent was sought. It's a path of least resistance. It's an easier argument to make to say you don't get inside the relevant insuring clause in the policy, so you you don't even get into cover in the first place, because it isn't defence costs sought without consent. That's all they would need to establish. Whereas for condition precedent, you'd have to prove the nature of the condition and that there had been a breach. So the effect is the same, but there wouldn't really be a scenario where I think they would have to establish it was a condition precedent as such. Then is there any scope to argue under a broker's PI policy? Um, what I would say about most of these points, I mean, everyone who knows Fenchurch law would know we don't act against brokers. So this may seem like a broker-friendly answer, but it actually happens to also, thankfully, be the honest one. That I think with all of these points, whilst we are saying that there is scope to try and potentially look at better terms, these are all sort of based on a certain set of facts and what could happen, and that you could potentially have terms that could be more favorable. I think that's very different from saying that it would be that a reasonable expectation of a broker is that they should necessarily advise on all of those terms, because we're talking about specific scenarios that may arise, which could always happen, and then saying in that scenario, it might be better to have these terms. Also, the availability of these terms as well, like take the contractual liability exclusion. Yeah, it would be lovely for financial institutions in an ideal world to not have a contractual liability exclusion. I'm not sure how realistic that would be. So potentially there could be claims against brokers, and maybe the brokers in the room should be alive to some of these points, but most of them, say with aggregation provisions, it's so fact specific about what's the best aggregation provision, it'd be quite hard to say to a broker, well, you should have told me to have narrow aggregating wording or wider aggregating wording, because there would be a different set of facts that could arise under that policy where the reverse would be better. uh, that's for you, I think, Chris.
Um, so we've got a question in relation to DCA. If an exclusion relates to claims arising out of attributable to rendering of commission, is that broader exclusion the example you spoke about? Yes, potentially. So that's the sort of exclusion where insurers have a better argument, is the short answer.
Have insurers started paying out? Probably too early, isn't it?
Yeah,
Yeah, it's probably too early because there's not been any.
yeah. So yeah, I can see there are a couple of questions which we could perhaps take offline. Um, but are at the time there. So should we call it, Dan? And
Yeah, we can address any others offline. Please, our contact details are there. So if you have any other questions or direct feedback for us or queries, please feel free to contact us directly. If not, then we look forward to receiving everybody's feedback and thank you for your time.